Who and what are covered by the FDCPA, the Fair Debt Collection Practices Act? Brought to you by YourLegalLegUp.com, your advantage if you are being sued by debt collectors. If you use credit cards, owe money on a personal loan, or are paying on a home mortgage, or if someone claims that you're a debtor within the meaning of the FDCPA. This video will outline some of your basic rights. You may be contacted by a debt collector. The Fair Debt Collection Practices Act requires that debt collectors treat you fairly and prohibits certain methods of debt collection. Debt collectors are entities that seek payment of debts that were or are claimed to have been owed to someone else at the time that they were generated. That is, money was originally owed or allegedly owed to a creditor and has somehow come into the hands of a debt collector who works on you to try to get the money paid. If it's a debt collection company hired by the creditor to bug you while the creditor still owns the debt, the act will apply. You might call that the classic debt collection scenario. The definition also includes debt buyers and law firms doing this work. What debts are covered by the FDCPA? Personal, family, and household debts are covered under the Act. This includes money owed for the purchase of an automobile, for medical care, or for charge accounts for personal items, among other things. It does not include debts created for business or income. How may a debt collector contact you? A collector may contact you in person, by mail, telephone, telegram, or fax. When may a debt collector contact you? A debt collector may not contact you at inconvenient times or places, such as before 8 a.m. or after 9 p.m. unless you agree to that. Likewise, if you tell them that other times are inconvenient, for example, if you work a graveyard shift, they can't call you at that time, but they can call you any other time. A debt collector may also not contact you at work if the collector knows that your employer disapproves of such contacts. You need to tell him. But you should never give a debt collector any information about your work at all if you can help it. How can you stop a debt collector from contacting you at all? You can stop a debt collector from contacting you by writing a letter to the collector telling them to stop, to cease and desist all further communications. Once the collector receives your letter, they may not contact you again, except to say that there will be no further contact or to notify you that the debt collector or the creditor intends to take some specific action. Sending such a letter does not make the debt go away. The debt collector could still sue you for it. It doesn't affect your substantive legal rights. I don't believe that sending a cease and desist letter makes it more likely that they will sue you, though, and possibly less likely. Whom can a debt collector contact about your debt? If you have an attorney, the debt collector must contact the attorney rather than you. You have to tell them that you have the lawyer, though. You can't assume that they'll figure it out. If you do not have a lawyer, a collector may contact other people, but only to find out where you live, what your phone number is, and where you work. Collectors usually are prohibited from contacting such third parties more than once, although they can seek to verify information if they need to, if they have some reason to think that a mistake was made. In most cases, the collector may not tell anyone other than you, your spouse, and your attorney that you owe the money. They break this rule a lot. What must a debt collector tell you about the debt? Within 5 days after you are first contacted, the collector must send you a written notice telling you the amount of money you owe, the name of the creditor to whom you owe the money, and what action to take if you believe you do not owe the money. May a debt collector continue to contact you if you believe you do not owe the money. If you send the debt collector a letter saying you don't owe the bill, that is disputing it, and seeking verification, then within 30 days of receiving notice from them, They've got to give you the verification before they try to collect money from you anymore. They have to verify before they can continue to try to get money from you. But if they filed suit for the money, this will not stop the court clock from running. You need to answer the lawsuit. You can't dispute the bill and hope the lawsuit will go away. If you do not seek verification within 30 days, you will lose the right to demand it from this collector. But you don't lose the right to halt all communications, as we talked about in the cease and desist letter, nor do you in any way admit the debt by your silence. See our video about things that debt collectors are specifically prohibited from doing or saying for more about your rights under the FDCPA. Protect what's yours and don't let the debt collectors rip you off. Debt collection is a social justice issue. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help others find our materials. YourLegalLegUp.com